Hello everyone and welcome to today's webinar. My name is Colin Spencer and today we will be discussing drafting and negotiation contracts. So it's essential tips to protect your small business. I'll say quickly for our subscribers on our legal advice plan, if you're watching this, I'd strongly recommend, if you're not already, get into the habit, get into the muscle memory of having your docs reviewed moving forward. Also, you do have those unlimited consultations with us. Use and abuse it, whether the call lasts 10 minutes or 30 minutes, just to get your answers questions. Get the green light on your documents, or if you'd rather the lawyer actually drafted in that specific clause or provision, obviously they can do for a small fee. Also, you have the ability to get that next working day consultation when you need it, and also we want to provide you with that service. For those of you who have no Scooby-Doo what I'm referring to, the contract review is probably one of the leading area of topics on our consultations. It's probably on their books, probably one of the most utilized services as a whole, and it's so unpopular. In fact, we're doing a webinar slightly related to it. All right, so we'll go into more detail shortly, of course. We'll cover a bit more about Lawpath, who we are, how we can directly assist. I'll introduce Damin, who will be discussing today's topic. Today Damin will be covering the legal requirements for a contract to be reviewed or to be considered valid and enforceable, those types of contracts, such as employment contracts, lease agreements, and service contracts, negotiating contract terms and clauses, common issues that may arise in the contract signing process, and e-signatures and their legal validity. Finally, we'll conclude with a Q&A session. So you'll be able to submit your questions in the Q&A chat box. It's separate from the one that just says chat, it says Q&A. But Damin, if you are open to it, I think it works a bit better if we can answer a few questions sporadically throughout the webinar, rather than risk being lumped with 40 all crammed in at the end. But speaking of which, today's webinar will be joined by and presented by Damin Murdock. He is Lawpath's principal lawyer. He has been practicing for decades and has extensive experience within this field, as well as other areas in commercial and business law. If anyone wants to view our Meet the Lawyers page, which I've shared in the chat there, you can see our lawyers who deal with our legal advice plan clients. You'll see, for example, on Damin's profile, he has a 5 out of 5-star rating out of over 300 reviews. For those of you who are new to Lawpath, then, we are an Australian-based online digital legal platform. We've been operating for over 10 years now, and this is actually out of date. We've actually helped over 500,000 businesses within that time frame in different capacities. We are essentially tailor-made for startups who need the service to fill in their gaps in legal knowledge, but also need it in such a way that saves them money with their startup costs. And if you're wondering who we assist in that 500,000, we work with a multitude of different businesses across different industries. General rule of thumb: if you have a legal commercial need, we can assist you in some capacity. And while we have lawyers and accountants using our platform, I think it's in fact about 8,000 of the 12,000 registered commercial accountants in Australia are using Lawpath. The bulk of our clients are startups who don't have any formal legal or accounting background. And most of the business owners I speak to, it's a case of them saying, I'm getting set up, I don't know what I don't know. That's where we come in, filling in the gaps, laying down the brick and mortar of their legal and accounting work. And for the individual business owner, save thousands of dollars in their fees. But within that last decade, we've actually saved small businesses over $100 million. And for anyone who would actually be interested in hearing that firsthand, on our website, on our YouTube page, and in the link I've shared in the chat, you can actually watch some video testimonials from our existing clients. You can see their names, their businesses, some of which will have businesses just like yours. And finally, there has been some recent changes in employment and contractor law. There is some upcoming changes, I believe, in legislation to data and privacy. So before we finish this calendar year, this will be the perfect time to get on top of your legal compliance. And to help give you that peace of mind, we will be offering a 20% discount on our quarterly legal advice plan for those attending this webinar. If that is of interest to you, please type in yes in the chat, or you can reach out to me directly. All right, that's enough from me. We'll cover the Q&A at the end, as I mentioned. I'll hand things over to Damin.
Great. Thank you very much, Connor. Hello, everybody. Thanks for joining us today. So we are going to talk about contracts and their just general formation. We're slowly going to progress to what the elements of a contract are, which lawyers talk about elements, things that you have to prove to establish something. And then we'll get into more sophisticated clauses. And hopefully Connor will ask me some questions. Hopefully you'll ask me some questions. And as we go, we can answer those questions to make it more involved. So the first thing is, what are the legal requirements to a contract? You probably know it, but there are some nuances to a contract that a lot of people might not know. So the first one is there an offer? And an offer comes in various different forms, but the first one is for there to be a contract, there needs to be an offer and acceptance. And it's amazing because if you look at a contract textbook, it's about this thick because an offer can be not an offer. So, for instance, there's something called mere puffery. And there was a case in England many, many years ago where someone had offered $1 million for them to buy something, and it was just a joke. And someone ended up buying it and claimed the $1 million, and it was found by the courts that that wasn't actually an offer, that wasn't a misrepresentation, that wasn't an inducement, it was mere puffery. So that's one example where an offer is not an offer. So where someone shakes your hand and says, I'll give you $1 million if you can run that mile in X amount of minutes. It might just be mere puffery and it's not a real offer. Another thing is a contract can be illegal. So if someone's going to buy drugs and you have an offer and acceptance, because the actual contract itself is illegal, the contract is illegal, and therefore the offer doesn't really exist. And another one is what's called an invitation to treat or an offer to bid. So if you go to the grocery store, for instance, and you see a can of Campbell's soup on the counter or on the shelf, and you grab that can and you take it up to the register, those products in the actual grocery store is not an offer for you to buy them. It's an invitation for you to treat yourself to make an offer to buy them. And it's when you actually walk it up to the counter and run it through the register, that's when you're making the offer and the grocery store is accepting it. So this all becomes more relevant when you're doing international transactions, like where was the offer made, where was the acceptance made, and defining on where the jurisdiction is going to be for the dispute if you don't have a jurisdiction clause. But I thought it might just be relevant for you to know that even though it looks like an offer, it might not actually be an offer, and you might just want to go and say, oh, well, maybe I'll ask Chat GPT whether that actually is an offer or similar. The next one is an acceptance. Again, acceptance isn't always just as simple as you think it might be. So for instance, if I made an offer to you, let's settle this legal proceeding for $10,000, and the other side says, how about 9? And I say no, and then they go and sign the deed of release anyway and send it to you by accepting it. That acceptance is no good, because when someone makes an offer to you and you make a counter offer, you automatically reject the original offer that was made, which means that offer is no longer. By making a counter offer, you're rejecting someone else's offer, and now you're making a new offer. So if you send an offer to someone and they say, and they try to bargain with you, and you say no, and then they sign the contract, well, it might be a case that their acceptance isn't legally enforceable, and you might not have to be bound by that contract after they tried to counter it. So again, just a little bit of things that you might want to know if you ever want to wiggle out of a contract, or if you ever need to enforce a contract. That's just some foundation things. The next one's consideration, and this is something that people miss a lot. And to be a binding contract, you need to be giving up something. So you need to be giving up a benefit for a detriment. So I'm going to work my time for you to pay me for my services, or I'm going to be employed for you to pay me a salary. But if there's no exchange of a benefit and a detriment, then it's not an actually legally binding agreement. So that's why we have what's called a deed. And you'll oftentimes see a deed for a deed of release. So an employee is working for your business, and and you terminate that employee, and you don't want that employee to bring an unfair dismissal case. So you provide them with a deed of release that basically says, I'll pay an extra 1 week if you sign this document. And the reason why it's a deed is because there's not necessarily any benefit or detriment being exchanged. And to have a deed, you don't need consideration. And that's the difference between an agreement and a deed. Another example of a deed is, for instance, someone loans you money, you receive the money, and then a couple weeks later, they say, well, let's sign this contract and for that loan. And if that's an agreement, it's it the rule is that bad or no consider or past consideration is not good consideration. So if you've already received the money, and then there's no reason for you to agree to sign a contract. So what's the benefit for you to sign a contract for a loan if you've already received the money? So you're not actually getting, there's no exchange of benefit or detriment. Now, if they threaten to sue you or demand for the money back right away if you don't agree to sign the contract, that might be a little bit different. But a lot of times you'll see a loan deed to deal with something that's already happened. And that's why we do a deed instead of an agreement. And then finally, it's the intention to form a legal relationship. We also call this a meeting of minds. And a lot of people say that a handshake deal isn't worth anything, or a verbal agreement isn't of any value. That's not true at all. The problem with a verbal agreement, one that hasn't been recorded in writing or drafted well in writing, is that a defense to an agreement is that there wasn't a clear meeting of the minds, meaning the people didn't actually understand exactly what they were entering into, and therefore a contract can be found unenforceable if it's vague, ambiguous, or uncertain. So a lot of times when people do a one-pager themselves, lawyers will jump in and say, well, that's not legally enforceable because it's vague, uncertain, and ambiguous, because there's so many different elements of that agreement that haven't been dealt with. And so for those reasons, the contract should fail. And oftentimes when someone drafts a one-pager, it does fail because it hasn't dealt with the essential clauses that normally are dealt with in a contract. And then also an agreement to agree is not legally enforceable. So if you were to say, we're going to enter into this memorandum of understanding or this heads of agreement, and it's not binding now, but we agree that we'll enter into transaction documents later. Well, it's probably not legally enforceable because you haven't, it's an agreement to agree to something in the future that you haven't agreed on. And therefore it's vague, ambiguous, uncertain, and it's an agreement to agree, and therefore the heads of agreement, even if it says it's binding, might not actually legally be binding, because if it's subject to do something in the future which you haven't agreed on, then it's a conditional agreement, and that condition is never satisfied if the parties never actually enter into those those contract terms or the transaction documents that were supposed to be drawn up later. Now, we talked about that briefly. So a deed is something that doesn't have consideration, as we mentioned before, but a deed also gets signed differently. So a deed is signed, sealed, and delivered. And what that means is that it is signed, and if it's an individual, it needs to be witnessed by a witness, an independent witness, witnessing the individual signature. It has to be expressed as a deed, so it needs to say it's a deed. The execution clause should say signed, sealed, and delivered next to where they're signing their name, and it has to be exchanged. So for instance, if I give you my cost agreement as a lawyer, I don't have any signature clause for my law firm to sign it. I simply send it off and get the client to sign it, because when I send it off, that's the offer. When the client signs it, that's their acceptance. That's okay as a contract, but as a deed, it's not, because it hasn't been signed by me. And so for that reason, you can't just have one party signing the contract and it being a bound deed or a binding deed, because you have to have both parties sign, seal, and deliver. You also have some e-signature laws that have come into place, and each state has a different law and how that applies. And a lot of that law might not apply to deeds, because deeds have a very old tradition and a lot of rules behind it, such as being signed, sealed, and delivered. And some of the states haven't actually dealt with deeds. So for instance, electronic signatures of a contract, you can just do an electronic signature. And a lot of the states have got rid of the requirement for an individual to have a witness. Whereas when you're signing a deed, normally an individual has to have their signature witnessed by somebody, even though they might be allowed to do it electronically. And if you have a witness, it has to be in the presence of, which means you have to have that witness. So if you get a document by DocuSign and you have a witness in the DocuSign, you can't just apply your signatures but not have it in the presence of, which means doing a virtual conference at the time of the witness witnessing your signature. Now, contracts can also be an express contract, which is something in writing, or it can be verbal, or it can be implied. And a lot of times, certain clauses can be implied into a contract. So, for instance, we have Australian consumer laws. And under Australian consumer laws, we have certain guarantees. And those guarantees in relation to the sale of goods, or guarantees in relation to the performance of services. So, for instance, there's a guarantee that a good will be fit for purpose. It will match the description that was provided. It will match any samples that were provided. It'll be of merchantable quality in terms of services. It'll be delivered with due care and skill. It'll be delivered within a reasonable period of time. It will be fit for purpose as well. And so these are all implied terms that automatically go into your contract, even though they're not specified in your contract. We also have under Australian consumer law clauses that deal with unfair contract terms. So where the contract is totally one-sided, or where there's a contract term that doesn't actually legitimately protect a business interest. So for instance, if you have a 12-month subscription contract and you say in that contract that if someone was to terminate early, there's no refund and they have to pay a termination or a break fee, it might be a circumstance that that clause is not legally binding, because under the Australian consumer law, an unfair contract term is one where it goes beyond what a company actually needs to protect itself. And so sometimes these break fee or locked-in contracts or automatic renewal clauses aren't necessarily going to be binding. You'll also see termination clauses where it might say one party can terminate under 5 different scenarios where the other person doesn't have a right to terminate at all. And these are imbalanced contracts. And a lot of times it used to be that people would say, well, we have website terms and conditions. We can put whatever we want in that contract because no one's going to read it anyway. And they're just going to tick to accept. And then we're going to be able to hold them to account to our contract terms because they signed it. But not only are certain clauses might be found to be unenforceable, directors can also be personally liable for trying to enforce unlawful clauses. So you want to try to draft your contracts that are fair and balanced, but you might have cases where you need to have a fixed term contract. So for instance, if you are selling subscriptions, I think back in 2009 or so, Fitness First took a case to court where they wanted their 1-year subscription membership fees to be a locked-in contract. And they won that case because they said, we have a need to know who's signing up to our subscriptions for or memberships for a year, so we can decide how many personal trainers are we going to have, when do we need to get another gym, within what radius, and there's a legitimate reason why we have it fixed term so that we have a business expectancy that those people are going to stay in those contracts, so that we can make business decisions to open up new gyms and things like that. Now, if we look at just standard employment contract, for instance, you have full-time contracts, part-time, casual. And a lot of times I've had people say, well, I'm hiring a casual employee, so I don't really need to give them a contract because they're just under the modern award. And if you don't know what a modern award is an industry-specific terms and conditions for an employee. So if you're in the retail industry, the retail award applies. If you're in construction award applies. If you're in manufacturing award applies, and it sets out the minimum shift that a casual is allowed to work, or the hours that they need to work, and things like that. So it just sets out the rules that might not be actually in your employment contracts. But one thing that's important is that you want your employees to be bound by your policies and procedures. And if you have no contract, then there's nothing there that's binding them to your policies and procedures. There's nothing in a modern war talking about confidentiality or intellectual property or non-solicitation of employees or restraint of trade or being allowed to delegate authority or delegate their duties to someone else. And so there's various different things that you normally would put in an employment contract that aren't covered by a modern award. So if there is anything when you have an employee that's going to vary, so maybe your commission structure, your policies and procedures, your work from home rules, you don't put those into the actual contract. Your contract is generally, your employment agreement is generally a fixed document, and you can't just randomly change it on the employee. The only way to change it is to get the employee to agree, and there's no reason for the employee to agree to sign a new employment contract normally. And so for that reason, you normally want to have your commission in a commission policy, which is separate, and your policies and procedures outside the contract. And your work from home, you don't want to say to someone, you can work from home 5 days a week, because maybe 20 years down the line, that employee is still working for you. You can't get them in the office because their employment contract says they're allowed to work from home 5 days a week. So you want to say, you have to work from our office, or if we don't have an office, from home, in accordance to our work from home policy. And then the work from home policy might say everybody's allowed to work 3 days a week from home, 2 days in the office. But in the future, you can change your policy and you can implement it over time, giving reasonable notice, making it fair and reasonable, and then you can slowly bring them back to work if you wanted to. Now, if you look at, for instance, lease agreements as well, there's certain essential things that have to be mentioned. You have to have who the tenant is, who the landlord is, what the duties of the landlord is, what the duties of the tenants are. There's a law behind retail leases, but there's a lot of things that aren't contained in the law to deal with what you want to be putting into a lease. So for instance, if you're about to sign a lease, and this is very common, it will say in the lease that you can't fit out the property without the landlord's consent. And so you say, okay, that's fine. I'll sign a lease and then I'll go in and I have a 3-month rent-free period. I'll go and ask for the landlord to consent to me fitting it out, taking down that wall, putting up this glass partition. And then you find out that the landlord's consent is then subject to the strata approval. And the strata only meets once a month. And you've just passed the most recent monthly meeting, and now the landlord can't consent to you changing it until they have had that strata meeting in a month from now, which means you can't actually start doing your fit out until you got the approvals. Or your fit out might require a development application, and the government might take 6 weeks to approve that development application. So if you do, or you're planning on signing a lease, you normally want to get the plans drawn up of exactly what you're going to do, and you want to get the landlord to consent to it before you actually sign the lease. Or alternatively, you don't want your rent-free period to start or your lease to start until the consent is given and the development application is given, and you've actually, or you've actually finished your fit out before everything ticks in. Otherwise, you'll miss your entire fit out period or rent-free period. Now, if you look at service agreements, you want to look at pricing. You want to what we often find is when it comes to any kind of contract, it's generally disputed because it wasn't clear. It's always a communications issue, or someone has oversold and underpromised or underdelivered. And that's because they might have had an outline of what they're going to do, but they haven't outlined what they're not going to do. So you get this a lot with accountants, for instance. An accountant will say, we'll do all your tax returns and we'll do all your business activity statements. And they enter into the agreement with me, for instance, as the director. But I might have a couple different businesses, and I might have my personal tax return, I might have a self-managed super fund, and then you start throwing in the accountant all these other entities, and then a dispute arises because the accountant says, well, I just thought you only had that one company. I didn't agree to do your personal tax returns. I didn't agree to do your holding company's tax returns. I didn't agree to do your family trust tax returns. And then it all becomes very messy. So if you are going to do a service, you want to make sure you specify what is included, what's excluded, and if it is excluded, what your costs are going to be to add it in, for instance. So you'll see, for instance, in a construction contract, it says we're going to build in accordance with this plan. This is everything that's included. If you want any variation, there's a detailed clause that deals with it. You ask for a variation, we'll quote it, we'll tell you how long it's going to take, and if you accept it, we'll do it, but you have to pay a deposit in advance before we start. So having a detailed contract does two things. It one scares the customer away because it's so comprehensive and so long that people might be afraid to actually sign it, but it also minimizes dispute. So when you have $1 billion contract, it's hundreds of pages long. But if you have a small $5,000 contract, you might just say, look, I'm going to reduce the size of the contract. I'm going to make it really short because I just want it something that's easy to sign and people don't have to see lawyers, and I'll take that risk. I know that if it all goes belly up, worst case scenario, I'll just have to refund the money, but I want people to be able to easily sign it. And so that's important when you brief a lawyer, you say, do you want it to be short or long, comprehensive, not comprehensive, easy to sign, not easy to sign? Connor, go for it.
I suppose one of my questions, Damon, do you find maybe especially after the fact when people are trying to reinforce their contracts, are their service agreements, are the clauses quite vague a lot of the time? They're not specific enough?
It depends. If someone drafted themselves, they're almost always vague because people, when they draft it themselves, they assume that it's just one line, right? Like, if you require a variation to this contract, you'll give us notice. But as a lawyer, we consider all the hypotheticals. So using this as an example, in the construction contract, it says if the builder needs to request a variation because there's been a change of a law, change of an error in the plans or specifications, the builder will ask for the change. They'll outline this. If an owner wants a change, that's the process. If they do accept the change, this is what happens. If they don't accept the change, that's what happens. And all the hypothetical scenarios are all drafted within that clause. So we often find clauses that have started. It's a good start, but it's not actually comprehensive enough to know the hypothetical situations of what happens if you don't agree to something. So, yeah, do you have any examples or any? I can only think of a variation clause because that's the most common scenario where it all starts getting messy. Because if you don't agree to a variation, but you need the variation, or else you can't continue the works, then a lot of times you end up having to terminate the contract.
Okay.
Some
Is there
other,
any, sorry, go on.
No, go ahead.
I was thinking, is there any kind of repeat offenders in terms of like the clauses here that people kind of miss? Like IP might be a big one, or as you mentioned, the scope of services.
Yeah, so if you look at non-solicitation, I'll run through them because I'll tell you what most of the mistakes are for every one of these clauses. So Scope of services, the biggest one is you talk about your services, but you don't talk about what's excluded. That's the number one issue. In terms of pricing and payment, you might have what the price is, might be a fixed fee. So let's say we're going to do this for $5,000, but it doesn't actually deal with what happens if you only part perform. So if you only part perform, are you entitled to the $5,000? So I had a multi-million-dollar Supreme Court case where my client did 97% of the job for 1.2 million, but the other side didn't do their acceptance testing. So there was a positive obligation on the other side when they received the software to do testing to make sure their software was good. And on my client side, being the developer, they did everything, but their contract said we only get paid once the other side does their acceptance testing, which means that if they haven't done their acceptance testing, then you're not actually allowed to issue your invoice under the contract, because that last step doesn't actually happen, and therefore you have no legal right under the contract to actually issue your invoice. So looking at if you have like milestone payments and things like that, making sure you pay a lot of attention to the payment process. Or you might have payments and payment dates, but those payment dates don't take into account to delays and things like that. So you've got to be really careful where there's stage processes or stage payments, how you actually draft the contracts. And then in terms of pricing, you might have like an automatic renewal clause, and it just automatically continues on. And you might have your fixed pricing, but it might be a case that your supplier just increases pricing significantly and you don't have a clause to pass on that cost. So if you have a pricing clause, you might want an ability to change your pricing by giving notice and giving them 60 days of your notice that your price is going to increase. And if they don't agree to that increased price, then they can terminate the contract. But at least you've made the pricing a bit variable in those scenarios. When you look at warranty clauses, a lot of times people say we don't give any warranty and there are no refunds. Well, that's not legally enforceable. There are circumstances where there could be no warranty or change of mind, but you have to be very careful. So, for instance, if you're buying clothing, there could be a case that there's no change of mind policy. But if it's defective, like there's a hole in it, or the length of the arms aren't equal, then it's going to be a breach of the consumer guarantees, and there is going to be a warranty. So you can't just stand by, we don't refund, and that's what we see all the time is people draft clauses that just aren't necessarily legally binding. And then in terms of confidentiality, a lot of people just miss that clause. They just forget to add it in. And intellectual property. So if you're an employee, the intellectual property that you create is owned by the employer during their performance of work in their job, while they're performing their roles and responsibilities. I had a case years ago, which is highly secretive, and my client just went delete. My client was the employee, and the employer was selling all the technology internationally for millions of dollars. My client just pressed delete on all the software. And they said, well, why have you just deleted the software? He said, well, that wasn't part of my roles and responsibilities. I just did that for my own good to help my job faster. It was an algorithm that I used, but my job wasn't to create software. My job was to be a physicist. And so you wanted to spell out intellectual property clauses that are really, really specific, like anything that you build or anything you make while you're employed is ours. Any invention that you come up with while you're employed is ours, because you've come up with that invention while using our confidential information. But then also what's important is if you have a contractor, all the intellectual property is automatically owned by the contractor. So if you don't have a clause that says that whatever the contractor is doing for you is owned by you, the contractor owns it. There might be an implied license that you get to keep the intellectual property and use it, but you don't own it. So You might not own your website, you might not own your logo, you might not own any of the software that you built if you don't have a specific clause dealing with intellectual property. Restraint of trade clauses, people get this wrong all the time. A restraint of trade clause needs three elements. It needs what is being restrained, a geographical location, and a duration of time. And if you don't have those three elements, it's not legally binding. And if you do have those three elements, it can't be against public policy. So you can't just say to someone, you're working in law now, you're not allowed to be a lawyer for 3 years. That's against gainful employment, is against public policy. But you could possibly say, you're not allowed to open up a law firm within 10 kilometers from our law firm, and you're not allowed to solicit our clients away. That probably would be legally enforceable. And then you just look at the period of time per industry, things like that. So those are the general, and then the termination clause is the biggest one. If you're ever signing a contract, look at the termination clause. It's always one-sided, unfair. It basically says the service provider can terminate whenever they want. You can't terminate at all. And people get locked into these contracts. And that's the biggest issue we find.
Awesome. Thanks, David. There's a question there, I think, for you from Ryan, and one from Adrian.
So binding or MOUs, MOUs are generally not legally enforceable. They're a memorandum of understanding, and normally the definition of a memorandum of understanding is that it's an understanding, it's not an agreement, and that's why it's called an understanding and not an agreement, not a deed, not a contract, because it's basically a mutual understanding, but there's no offer, there's no acceptance, there's no consideration. It's normally subject to something in the future. But you can put into it saying this clause and this clause is binding. So you'll see oftentimes in a memorandum of understanding, it says this is not binding, but the confidentiality clause is binding, the geographical location is binding, and this clause is binding. But generally, they're not legally enforceable. You can't do anything with them unless you make them binding. You could call it a memorandum of understanding and then have a detailed clause saying, even though this is what it's called, it's binding. But then it goes to a point where you might not actually have all the elements that are required for a contract. And even if it says it's binding, it still might not be a legally binding agreement because it doesn't meet the requirements of a contract. I think, Connor, you had another question dealing with so if you actually sign a contract that is vague and unenforceable, what are the ramifications for that? And it's a two-edged sword here, is that you sometimes you want to put in clauses that are going to support your position. And it might be questionable whether it's legally binding or not. It might be, I don't know whether it's legally binding. I don't know whether I'm going too far, but I'm going to put it in anyway. And that's okay sometimes, because at least you'll have leverage when someone's disputing you. You can point to that clause and say, this clause we're relying upon, and you can't get out of the contract simply because you want to, because this is what the clause says. And it says you can only terminate in these circumstances. And so it gives you that leverage. It also means that if anyone was ever to sue you, it gives you the benefit that you would automatically have a defense. And so it creates a leverage for you to negotiate. It creates a defense if you ever have an issue. But on the other side, if you are trying to enforce an unlawful contract, it could backfire in your face significantly, because you could run an entire case, find out you were wrong, and have to pay everybody's legal fees. And then on the other side, if you know a clause is legally unenforceable, but you say, you know what, I'm just going to sign the contract anyway, they won't be able to rely upon that in the future. Well, then the problem there is you've signed a contract, you've read the clause, you kind of understood what that clause meant, and now you want help from the court saying, I knew what it meant, but I just assumed it wasn't legally enforceable. Well, the court might not help you there. And remember that if you sign a contract that you know shouldn't be legally enforceable, or a clause that shouldn't be legally enforceable, and then you want to try to get around that clause, the only one that can tell you that that clause actually is legally unenforceable is a judge. And to get to in front of a judge is normally going to take a long time and a lot of money if you're going to hire lawyers. So if you're running an entire case relying upon a clause that might be unenforceable, or you're relying upon an entire defense on a clause that you're trying to get out of, you might not know after $100,000 legal fees are expired, and then be very either pleasantly surprised or be very, very disappointed if you win or lose a case. So it's much, much better to try to get it right. And if you don't like a clause, try to negotiate it. And if you don't like a clause, tell them that's not legally enforceable. Go into Chat GPT, try to find out why that clause isn't legally enforceable. Tell them why you think it's not legally enforceable and try to get it amended so that it's more fair and reasonable. Now, if you look at negotiating contracts, generally you want to look at the termination clauses. As I mentioned, a lot of times people don't even have a termination clause, and that becomes a major issue. But yeah, look at how long is the contract, how does it renew, what happens if you want to get out of it, what happens if your client wants to get out of it, how do you vary it, how do you change it, how do you renew it, are you covering all the warranties that are normally there, are there any clauses that just seem unfair and you're not sure about that might not be legal enforceable. These are all things that you want to look at. Normally, you're also looking at limited liability clauses, disclaimers. Those are also important. Indemnity clauses. A lot of people don't know what indemnity means, but generally speaking, it says that, I'll just give it as an example. I'm going to develop software for your business. I promise that all the software that I am going to make for you is owned by me, and I have a right to do it. And so then I deliver the software to you, and 3 years down the line, you get a letter of demand from a big software company saying that the code in your software is actually theirs, and they're going to sue you for infringement of their copyright for hundreds of thousands of dollars. Now, if you had a clause in the agreement with me when I developed the software that says that I promise to you that I own all the software and I'm not using any open source code without a license, and that I indemnify you from all loss and damage as a result of a breach of that promise, then what that means is that when you go and get sued by this big multinational who's claiming that you have copied their intellectual property, you can sue me for my breach of my warranty under the contract, for breach of contract, for your damages, but you can also seek indemnity, which means all of your legal costs in defending against that case, all of the costs that are ordered against you, if you lose that case, basically everything that's out of pocket, it's a full indemnity. It's to put you back in the same position as you would have been, but for that initial warranty going wrong. So that's basically what an indemnity is. So you want to have a look at that. So if it says, if you say, I'm going to deliver this by this time and I indemnify you for all your loss and damage, then when you don't deliver on time, they could possibly sue you for lost profits, lost business, lost reputation, all these other things. So you want to make sure that consequential loss is excluded from a contract. Loss of goodwill, loss of profits, loss of revenue, loss of reputation, all that generally you want to be excluded from your contract. When we look at one thing I'm also going to mention is when you're signing a contract, make sure you get the parties right. There's so many times where, there might be, for instance, you might sign a contract with Lawpath and it just says Lawpath and Damin. Well, is it Lawpath and Damin? Well, who is Lawpath? Lawpath Legal, Lawpath Operations. If you don't actually have a party specified in the contract and you can't get that right, you don't have anyone to sue. You don't have a contract to enforce against anyone because you haven't even got the contract right, because you don't have the parties right. So You can go to ASIC, ASIC, ASIC. If you just go to Google ASIC Connect online, put those 3 words in, takes you to a website. You can go and you can check for a business or organization. You can type their name in, and it'll come back with their full legal name and their Australian company number, their ACN or their ABN, the Australian business name. Throw that into the contract, because we see that quite a bit. People just get the wrong party or don't have a party actually signed to the contract. Now, also have a look at rights and responsibilities. It's so common where we see that a software developer, I use that as an example because a lot of people with Lawpath are in the tech space, but a software developer will say, we will do this, do this, do this, do this, but it doesn't say anything about the customer, where the customer should have obligations coming back as well, like, we will respond to your inquiries, we'll give you instructions, we'll give you approvals, we will respond to your requests within a reasonable period of time, but not more than 3 business days. We will provide you with all the information that you need. We will do this, we will do that. So both parties to every contract should have obligations going back and forth and rights. And without it, you're going to have a difficult time because you might not be able to deliver your service without the other side giving you feedback. You might not be able to sell a good if the other side doesn't tell you the address of where it's going to, or doesn't show up at that address, or is never around. So there's a bunch of different things that you want to consider when getting your contract right. And so what happens if the contract goes bad? How do you actually resolve it? If you're providing services to someone internationally and it says that Australian law is the applicable law and the jurisdiction's Victoria to resolve the dispute, that's great. But if your customer's in New York and they have no assets in Australia, then you can go and sue them here and get a judgment here, but it's not worth a penny because they don't have any assets here to enforce them, to do anything. So you now have a judgment that you can't do anything with because we don't mutually recognize judgments from the United States. So generally, if you're going to do business internationally, you do what's called arbitration. And there's it is the International Convention of the Foreign Recognition and Enforcement of Arbitral Awards, 1958. And that's basically in short form called the New York Convention. And it says people to a commercial contract can agree on what the jurisdiction is, what the applicable law is, and contract out of court. And it basically says, so then in those circumstances, you could be in Melbourne, they could be in New York. You can say Victorian law applies. If we're going to have a dispute, it's going to be by way of arbitration in Australia, in Melbourne. And then if you have a dispute, you can go to arbitration, you can get an arbitration award. Then that arbitration award's good in about 151 countries around the world. And you can walk up to a court in New York and say, here's an Australian arbitration decision. Please stamp that as if it's a judgment from New York. And under the New York Convention, they have to stamp it. And now you have a New York judgment. So some things to think about if you want to have how you're going to resolve the disputes. Other things is sometimes people just always put in a mediation clause. But if your contract's only for $1,000, do you really want to lock yourself in a room for 8 hours trying to resolve $1,000? You're better off just go straight to court and run a debt claim in small claims jurisdiction, or go to VCAT or NCAT or QCAT, the small tribunals, to recover that money. You don't want to have to go through an arbitration or a mediation over $1,000. So have a look at what your dispute resolution process is. Make sure your intellectual property is protected. Make sure you've checked your limited liability clauses. And then when you look at negotiations, lawyers will normally try to negotiate, let's just say 10 things, but there's really only about 6 that they actually want. So if you start off with 10 points and you go into the negotiation, the other side might accept 4. Well, now you can say, well, I'll give up 1 if you give me this 5th one, and I'll give up 2 if you give me this one, and so that you can get up to the 6 that you actually want. So sometimes you try to negotiate a little bit more aggressively than you actually need. And that's where we have the high ball offer and the low ball offer. Generally speaking, even though everybody knows it's going to meet it in the middle eventually, you generally always start on the high ball. If you ever watch Pawn Stars or anything like that, where they're negotiating, it's the worst negotiations because someone will walk in and try to sell a baseball sold by, signed by someone, and they say, I want $900 for this. And they're like, yeah, I don't know. What's the best offer? Oh, I'll take 6. And then they'll say, okay, well, we'll make an offer of 3. And then they settle at 4. By they just made a bet against themselves. They started at 9. They told them what the lowest they're willing to accept. And now they're going to even get them lower. So you generally don't negotiate against your own self by making 2 offers. So you make an offer, they say, no, it's out of the ballpark. We're not going to do it. You say, well, give me an offer, whether it's low ball or not, doesn't matter. Just give me an offer and then I'll come back. But if you just keep on betting against yourself, you're just going to drive yourself down. And that's the worst way to negotiate. So from a strategy, generally take about 10 points, try to get the 6, give up certain points for things that you actually want, and make a high ball offer generally, or something with some meat in it where you can come down, and don't bet against yourself. And then just the final things is people often hire lawyers. They go through all the trouble of getting that contract going back and forth, and everybody's negotiating, everybody's happy, and then it just kind of falls away and they just start doing the business anyway without a contract signed. Or they start doing the business with the intention to sign it once they're halfway through. It just doesn't work that way because 1, there's no consideration because you've already started the work, and number 2, the other side just won't agree to sign the contract, and now you're stuck halfway through with no way out without any kind of contract signed. So don't start a project without a contract signed, no matter what anyone says, and make sure it's signed correctly. If it's a contract, make sure it's properly witnessed if it has to be witnessed. If it's a deed, get it witnessed. Make sure the party's correct, and don't just start and agree to sign a contract in the future, because that's the worst thing you can do. And 9 times out of 10, you'll be left with no contract, or you can't negotiate the contract anymore because you've already so deeply seated and so deeply rooted in that project that you can't get out of it. So now you've just given up all your leverage, and you just got to accept whatever you can get. Sole traders normally are individuals. Normally you should have a person witness your signature if it's a deed. Companies, 1 director signs, 2 directors sign, 2 directors and a secretary, either 2 directors or a director and a secretary. You need 2 people. And then finally, if we look at electronic signatures, you got to have a look at your own state. Every state's different, but generally speaking, most transactions now allow for agreements to be signed electronically. So I'll pass it back to Connor for a minute, and then you can drop your questions into the Q&A, and then we'll get into the Q&A.
Awesome. Thank you, Damin. A really quick one from me. No big spiel. I would just have to say, if you do have any questions and you want more detail in terms of our scope of services, would want a platform demo or want more info like on our tax and accounting or asset compliance, just type yes in the chat or reach out to me directly via email. We can just have a quick phone call and I can answer your questions. That being said, just 2 things I really want to share with everyone. I noticed as well quite a few people on this webinar I think are existing subscribers, so I think everyone's pretty across what we do as Lawpath, as a bit of a one-stop shop for your businesses. However, if I just go to the next slide, Damin, or not, and the next one, thanks, mate. So we have our essentials and legal advice plan here. So really quickly, we cover a litany of topics on the legal advice plan. It's the most popular subscription. It includes all our documents plus the benefit of unlimited consultations with our lawyers and the unlimited on-call contract review. So very near and dear to today's topic. We typically cover things around business structuring, business purchase and sale, the employment and HR advice, IP and trademarking, debt recovery, commercial property and law, to name but a few. But if you're still unsure and wouldn't know where to begin, just kind of two things I wanted to share. Just go to the next slide, Damin. We have here our accelerator program. So we have one for the legal advice, we have one for the accounting advice. These are excellent starting points, whether in your first year of business or 5 years in business. These are designed to give you, bang for your buck when you're using our platform. So it's a review of your business structure, protecting your brand, your IP, auditing your employee agreements and policies with our lawyers, reviewing your supplier and commercial agreements, auditing your privacy and insurance policies, and finally how to get capital raising ready. There's actually a part 2, I believe. I think it's a total of 10 topics. We also have here our legal projects. So these are largely add-ons. So we have like our company secretary program, which is basically our business compliance to review your asset company register, protecting your brand. So if you want to complete a trademark review, speak to our lawyers, you can get advice on that. Accounting, so we can audit your current lodgements. We have a partnership with Pot Business, but we also have the Lawpath Tax and Advisory to kind of go through all that with you. And finally, preparing an employee handbook. We actually already have an employee handbook on the website. You can get a tailored one drafted to you by our lawyers for additional fee. And finally, I'd say the second thing is we have obviously these new bundles and deals, but often the starting place for a lot of new subscribers is what we call a discovery call. So obviously you can address any high priority short-term concerns there, but it's really basically the first step in describing your business in detail to the lawyer and exposing any legal gaps that you may be unaware of. So that's basically it from me. Do reach out if you have any further questions and want more info. We have here the unlimited legal advice coupon on our quarterly plans. It's 20% off, so do make use of that while we're offering it.